So this is my judgment. I have given due consideration to all the processes and the submissions of the parties. I need to start with a few remarks. Firstly, the law is that a reply on point of law is meant to be just what it is. It's a reply on point of law. It should be limited to answering only new points arising from the opposing brief. It is not meant for the party its case or bring in points it forgot to advance when it filed its final written address. It is not a forum to engage law. It should be limited to answering only new points arise from the opposing brief. It is not meant for the party replying on point points of law to re-argue its case or
letter B. Letter 6 B 3 A D.
Is not reliable. How about billions of money that they make on daily basis? Billions of money that they make on daily basis. Yes, they cannot provide reliable.
Recording in progress.
Can we continue now?
My Lord, we can hear you. Yes, my Lord, we can continue.
I do not know if counsel is that this presiding judge is already employee of this court. In the circumstance, counsel can, at best, in his prayers. I indicated earlier that the defendant objected to U2 and CW5 at the hearing of this suit. Exhibit CW1 is defendant's letter of offer of contract appointment to claimant dated November 27, 20. Exhibit CW2 is claimant's letter to the chairman of the defendant dated December 5, 2017, titled Application for the corrected CW5. The court had directed counsel to the defendant to address the court 0 to 5.04, but has elected to address the court on Exhibit CW5. In effect, it stands to reason has abandoned its objection to the admissibility of Exhibit CW1 and CW2. Therefore, both stand admissible accordingly as exhibits in this suit. I so hope. The defendant contends that the claimant failed to comply with Section 84, Sub 1 of the Evidence Act 2011, as claimant only dumped Exhibit CW5, a Techno Y4 mobile phone, on the court without any printed copy, excuse me, on the contents of the alleged message conversation between the claimant and the defendant's employee. That defendant's counsel could not even assess the contents of the said mobile phone, as same was completely off and non-functional. That the essence of law of evidence is discovery of the truth. He cited Oregon and another versus Fidelity Bank PLC, Supra. In reaction, the claimant maintained that the text messages contained in Exhibit CW5 were produced by Techno WIFO during a period which the Techno WIFO was used regularly to store or process information for the purposes of any activities regularly carried on over the period that what guides admissibility is relevant, that Exhibit CW5 is very relevant to this suit, that Exhibit CW5 was equally pleaded and duly complied with the requirements of Section 84 of the Evidence Act. On the conditions precedent for admissibility of electronic evidence, the law as stated by Section 84 sub 2A of the Evidence Act 2011 on the conditions precedent for admissibility of electronic evidence, the law stated Section 84 sub 2A of the Evidence Act 2011 is that the document containing during a period over which the computer was used regularly to store or process information for the purposes of any activity regularly carried on over that period, whether for profit or not, by anybody, whether corporate or not, or by any individual. In a case where writs are kept by a mobile phone user, such written records are admissible to prove and or collaborate the core logs on the said GSM phone, as stated in the case of R versus Singh, where the holder of the GSM phone kept a separate notebook which he recorded numbers he had saved in the memory of the GSM phone. In this case, it was heard that evidence in the notebook in which the user traced to the defendant was admissible to show that the number saved belonged to the defendant. In paragraph 3 of his amended statement of fact, facts. The claimant pleaded the text message communication correspondence between him and the defendant CEO, as clearly found in the claimant's Techno Y4, and shall rely on all the text message conversations between him and the defendant CEO as saved/contained in the said phone during trial. His Lordship, the learned author, Alaba Omolaye Ajileye, in the book Electronic Evidence, Revised Edition 2019, discussed the ambit of the law relating to admissibility of SMS and instant messages, IM. For instance, the learned author stated at pages 314, 315, and 316 thus, quote, "The easiest way to authenticate a text message is to have the opposing party admit that he sent it. This is on the basis of the principle that what is admitted need no proof. Like emails, text messages have certain seemingly self-authenticating features. For instance, a text message is marked with the sender's cell phone number. May not have originated from the person to have sent it. See Commonwealth versus Koch. The citation is supplied. That emails and text messages are documents and subject to the same requirement for authenticity as non-electronic documents generally. The court ruled further that to prove that she had sent the message in question. The court declared that parties to introduce electronic materials such as cell phone text messages and email must prepare to substantiate their claim of authorship with circumstantial evidence, in quote, that corroborates the sender's identity. That evidence may come in the form of testimony from the sender or recipient or witnesses to the creation of the correspondence or even contextual clues in the message itself. Close of quote. The claimant's argument that the text messages contained in Exhibit CW5 were produced by Techno Y4 during a period in which the Techno was used without the user producing the document containing the statement/text messages therein is, in my contemplation, hollow and does not satisfy the requirements of Section 84 of the Evidence Act 2011. The argument of the claimant that the defendant's counsel never requested to access or read the content of the defendant's in open court, in my view, is starkly disingenuous. It's a starkly disingenuous way of passing the buck and laying his burden of proof on counsel to the defendant. It is not done like that. Exhibit CW5 dumped on the court by the claimant. It is impishly composed of unresolved issues for the reasons stated above for purposes of this judgment. I so hold. Given the reliefs claimed by the claimant, the issues before the court are the unilateral termination of claimant's contract by the defendant was wrongful and unjustifiable. Whether the claimant is entitled to be paid unpaid remuneration from August 2017 to December 2017, and expenses claimant expended in the course of his employment with the defendant, general damages and cost of this suit. By which the claimant in the instant case is said by the defendant to have resigned is Exhibit DW4. In paragraphs 9, 10, 11, 14, 15, 16, 17, 20, 23, and 24 of the statement of facts, as well as the supporting disposition in paragraphs 9, 10, 11, 14, 15, 16, 17, 20, 24 of CW's depositions on 26 November 2019. On the 20th August 2017, he and others were summoned to a management/staff meeting of the defendant, wherein the defendant informed the claimant and other staff present that it would commence project at the new map in Abia State. That is Nigeria Erosion and Watershed Management Project in Abia State, the next day being 21st August 2017. And the claimant would specifically work there as his geotechnical engineer, that the claimant accepted to work that the claimant at the said site on the condition that he would be paid 180,000 naira as remuneration, and same was accepted by the defendant. But in spite of the fact that the date earlier scheduled for work at the new map site was botched, the defendant, during the intervening period, initiated series of management/staff meetings attended by the claimant. That as a follow-up to such meetings, claimant with other staff kept visiting the new map project site for site inspection. That perturbed by the non-issuance of appointment letter to him, the claimant notified / reminded the defendant CEO after one of such strategy meetings, having been absolved as one of the defendant's staff, clearly evidenced by a series of conduct and oral agreement thereto, there was need to avail him an appointment letter to further formalize, concretize, his appointment, and that the said appointment letter must take cognizance of the fact contract between them started in the month of August 2017. That the claimant later received with great shock and dismay an offer of contract of employment letter dated 27th November 2018 from the defendant, stating that his appointment took effect from Friday, 4th November 2017. That claimant raised the issue in one of the meetings with the defendant and was assured that the mistake in the date of commencement would be corrected. That as further directed by the defendant, he put his complaint in writing via a letter dated titled application for the correction of my date. That on 9th December 2017, sub 1 to 11 and 4 and 2 to 6 of its statement of defense, as well as the supporting deposition in paragraphs 3 to 21 of DW's deposition of 2nd December 2019. In the above the employee, or in the circumstances of the employee being or herself to entitle the tribunal of fact there was no real resignation despite. By Western Excavation, EEC Limited versus Sharp, Lord Denning had this to say: if the employer is guilty of conduct, which is a significant breach going by the route of the contract of employment, or which shows that the employer no longer intends to be bound by one or more of the essential terms of the contract, then the employee is entitled to treat himself as discharged from his federal contract by reason of the employer's conduct. He is constructively dismissed. The employee is entitled in those circumstances to leave at the instant without giving any notice at all, or alternatively, he may give notice and say he is leaving at the end of the notice. But the conduct must in either case be sufficiently serious to entitle him to leave at once. Moreover, he must make up his mind soon after the conduct of which he complains of. If he continues for any length of time without leaving, he will lose his right to treat himself as discharged. He will be regarded as having elected to affirm the contract. I must treating contracts of employment. Ambiguity must be resolved in favor of that which gives the employee an advantage. See Owulade versus Nigerian Egypt Oil Company Limited. And Mr. Chiruma versus Fortress Oil PLC. The citations are supplied. The claimant might as well have opted to resign as indicated in Exhibit DW3. However, construed pari passu, Exhibit CW2, that is application for the correction of date of appointment, and Exhibit 4, which is request for his entitlements, defendant's condonation at the law stated in the authorities above. It is my determination that the defendant unilaterally and constructively terminated the claimant's contract to hold. Relief B and C are claims for monetary sums. The first for 796,154, being the claimant's outstanding sum of his unpaid remuneration from August 2017 to December 2017, before the defendant's contract with the before the claimant's contract with the defendant was unlawfully and unilaterally terminated by the defendant. And the second for 18,400 naira, being expenses the claimant expended in the course of his employment with the defendant. The argument of the defendant is that the claimant is not entitled to the relief sought in this claim, that the sum of 18,400 arose out of the claimant's imagination because no approval, written or oral, was given to him to use his personal money, and indeed no such expenditure was done by him. Release B and C are claims for special damages, which must be specially proved, pleaded, particularized, and specifically proved. C7 Bottling Company PLC versus Augustus, and NNPC versus Cliff Co. Nigeria Limited. Claimant remunerations and expenses means claiming remunerations and expenses means that the court must be told in the pleadings what the claimant's salary and expenses are upon which he lays his claim. There are no such pleadings in the amended statement of facts. The law is that pleadings without evidence go to no issue, and evidence without pleading versus SPDC versus Kwame Amba. The citations are supplied. This means reliefs B and C have not been proved and so cannot be granted. I so hold. Relief D is for general damages in the sum of 10 million against the defendant for wrongful termination of employment. Since the claimant succeeded only in terms of relief A, I assess the damages awardable at 1 million naira only, which must be paid by the defendant to the claimant for wrongful termination of employment. Relief E is 2 million as cost of this action. Although costs follow events in litigation, it is at the discretion of the court. See NNPC versus Cliff Co. Nigeria Limited. On the whole, claimant's case succeeds in part and only in terms of the following declarations and orders. 1, it is hereby declared that the unilateral / constructive termination of claimant's contract by the defendant was wrongful. 2, for wrongful termination of employment, the defendant is to pay the claimant within 30 days of this judgment the sum of 1 million naira only as damages. Failing this, the said sum shall attract 10% simple interest per annum until the said sum is fully paid. Judgment is entered accordingly. I make no order as to cost.
As the court pleases.
As the court pleases. We are grateful, my Lord.
Thank you. The court will write. Yeah. The court